Hello, my name is Courtney Thompson, and this presentation analyzes two landmark Supreme Court cases that fundamentally changed the landscape of American defamation law. New York Times versus Sullivan and Gertz v. Welch. I will explore the facts of each case, the specific legal standards established, and how these rulings continue to shape the work of communication professionals today. Part 1, New York Times versus Sullivan. We begin with New York Times versus Sullivan, a case decided in 1964. The dispute arose during the height of the Civil Rights Movement. The parties involved were L.B. Sullivan, the Public Safety Commissioner of Montgomery, Alabama, and the New York Times Company. The conflict began when the Times published a full-page fundraising advertisement on March 29, 1960, titled "Heed the Rising Voices." The ad solicited funds to defend Dr. Martin Luther King Jr. and support student protesters. The content that triggered the dispute involved descriptions of police actions against peaceful protesters in Montgomery, Alabama. Sullivan sued for libel, arguing that although the ad did not mention him by name, it defamed him by inaccurately portraying the police force he supervised. The advertisement contained several factual errors regarding the police response. For example, the text claimed that after students sang "My Country, 'Tis of Thee," quote, truckloads of police armed with shotguns and tear gas ringed the Alabama State College campus. It also stated that when the student body protested, quote, their dining hall was padlocked in an attempt to starve them into submission, end quote. Sullivan felt his reputation was damaged because, as the commissioner in charge of the police, he believed these accusations of misconduct and brutality were implicitly directed at him. He argued that the word police and assertions of intimidation and violence effectively accused him of dereliction of duty and criminal behavior. The central legal question was what standard proof a public official like Sullivan must meet to win a defamation suit. The Alabama courts had applied a strict liability standard similar to negligence, where falsity alone was not enough to win damages. However, the Supreme Court established a much higher burden of proof. They ruled that a public official cannot recover damages for a defamatory falsehood relating to their official conduct unless they prove that the statement was made with actual malice. This means Sullivan had to prove that the New York Times published the ad with knowledge that it was false and the reckless regard of whether it was false or not. In a unanimous decision, the Supreme Court ruled in favor of the New York Times. Justice William Brennan, writing for the court, argued that the First Amendment requires breathing space for free speech to survive. The court's reasoning was that public debate should be, quote, uninhibited, robust, and wide open, end quote, and that this may well include vehement, caustic, and sometimes unpleasantly sharp attacks on government and public officials. If the press were held liable for every honest factual error, it would lead to self-censorship. Because Sullivan could not prove the Times acted with actual malice, his claim failed. Part 2, Gertz v. Welch. Now we turn to the 1974 case of Gertz v. Welch. The parties here for Elmer Gertz, a reputable Chicago attorney, and Robert Welch, Incorporated, the publisher of American Opinion, a magazine run by John Birch Society. The key issue was Gertz's status. Unlike Sullivan, who was an elected commissioner, Gertz was a private lawyer hired by a family to sue a police officer who had killed their son. Although the publisher argued that Gertz was a public figure because he was involved in a high-profile issue, the Supreme Court ultimately determined that Gertz was a private individual. He had not thrust himself into the vortex of public controversy nor sought fame. He was simply doing his job as a lawyer. The American Opinion article, titled "Frame Up," made wild and damaging accusations against Gertz to support a conspiracy theory that there was a war against the police. The article falsely labeled Gertz as a, quote, Leninist and communist frontier, end quote. It further claimed that he had a criminal record and was the, quote, architect of the frame-up, end quote, against the police officer. These statements were objectively false. Gertz was not a communist and had no criminal record whatsoever. Remarkably, the publisher made virtually no effort to verify these serious allegations. The managing editor admitted during the trial that he did not independently check the facts. Instead, he relied entirely on the author's reputation, despite the author having a known history of making conspiracy-laden claims. The harm to Gertz was significant. As a prominent lawyer, his professional standing relied on his integrity. Being publicly labeled a Leninist and a criminal during the Cold War era was a direct attack on his character, potentially alienating clients and destroying his standing in the legal community. The publisher could have easily avoided the lawsuit by performing basic fact-checking. A simple check of court records or a call to the Bar Association could have revealed that Gertz had no criminal record and was not a communist official. Ultimately, because Gertz was a private individual, the court ruled he did not have to prove actual malice to recover actual damages. He only needed to prove that the publisher was negligent, that they failed to exercise the care a reasonable person would take. This established that private citizens deserve more protection from defamation than public officials. Relating these cases to future work in the communications industry, 3 key lessons emerge. First, status matters. We must always determine that if the subject of our content is a public official or even a private citizen, as the legal risks are higher than when writing about private individuals. Second, verification is non-negotiable. As seen in Gertz, failing to verify facts can lead to devastating legal consequences, even if you truly trust your source. And third, while Sullivan gives us the freedom to debate public issues robustly, it is not a license to be reckless. Maintaining credibility requires us to pursue the truth diligently, not just to avoid lawsuits, but to uphold the ethical standards of our profession. This concludes my presentation on the New York Times versus Sullivan and Gertz v. Bosch. The slide shown here lists the references used to compile this analysis. Thank you so much for listening.